All right, 9 a.m. Let's go ahead and get started. So, welcome to my WTF class, which is what's that form? Potentially also but we'll just call it what's that form. And we are going to go through the AAR exclusive right to sell rent, aka the listing contract, aka the listing agreement, aka the ER. This poor form has so many different nicknames that I don't even know that it knows how to identify anymore. So, we're going to try to help it out. If you have attended a class on this form in the past, you maybe know the majority of it. However, for those who aren't aware, it was most recently updated on February 1st. It was previously updated on August 1st. So it's had a lot of iterations in the past couple of years. So we're going to try to do it justice and give it a little attention today. So a couple of ground rules before we get started. Please keep yourself on mute unless you are asking a question. Please ask questions out loud. So do unmute yourself in that situation so that I don't have to monitor the chat box. And don't worry about taking screenshots, as I will send this slide deck and a link to the class recording to everyone who registered. So that's why I make agents register, because that way I have your email address so I can send things out after class. For my agents especially, please pay attention while I have you. We have our annual Day of Giving Back coming up on April 26th. So if you are interested in joining us for our one day, we are actually going to be planting trees at a local park. There's a whole bunch of studies on why this benefits the community and lifestyles and all of that good stuff. So we would like anyone 18 and older to help volunteer that day. So please reach out if you are interested and available so I can mark you down. It's my little shameless plug there. All right, let's go ahead and get this party started with a poll. All right, can everybody see the poll on their screen? ER poll one, perfect. Okay, so other than the form name, is there a difference between the EA, exclusive agency, and the ER, exclusive right to sell? Number two, can a property be simultaneously listed for sale by one broker and listed for rent by a different broker? Number three, generally, what is the maximum term allowed for a listing agreement? There is no maximum. It's whatever the seller and listing agent, listing broker agree to. 2 years or 12 months. True or false? Should the seller wish to offer compensation to a buyer broker, there is a line on the ER where they may do so. There's a few here, so I'll give you a couple of minutes to answer these. Five seconds. All right, let's see what we got. Other than the name of the form, is there a difference between the EA, exclusive agency, and the ER, exclusive right? Excellent. Look at all of you, so good. Now, what brave soul wants to unmute themselves and tell me what the difference is? You had to know that was coming. Bueller? Bueller? Methinks many of you cheated on this and you don't really know what the difference is. You just feel that they have different names, therefore they must be different. So here's the overall difference between the two. So an exclusive agency actually allows a seller to sell their home on their own and not owe the listing broker commission. It's probably a big deal, something you might want to know. So the moral of this story is, unless that is the intention, and I doubt it is, please make sure that you are using the exclusive right, which means that no matter why or who sells that property during the term of your listing agreement, you, the listing agent slash listing broker, are entitled to compensation. Number two, can a property be simultaneously listed for sale by one broker and listed for rent by a different broker? The answer to that is yes. So they are fulfilling different roles, different needs. You would have ERs that are marked independently. So one would be marking the box for sale, the other one would be marking the box for rent. You could have two lock boxes, two signs, and there'll be two MLS inputs. Generally, what is the maximum term allowed for a listing agreement? So, if you have been keeping up with some changes that we had to our statutes last year, the answer is 12 months. Now, there are some caveats to this, but generally speaking, the limit, and this really wasn't designed to limit all of you, it was had other intentions behind it, but the limit is 12 months. So, if you are considering taking one longer, chat with your broker to make sure that it is acceptable based on the circumstances. Now, keeping in mind, you can always extend, so that's not a problem. This is referring to the initial or original listing agreement. True or false? Should the seller wish to offer compensation to a buyer broker, there is a line on the ER where they may do so. Oh, some of you aren't aware of the change that happened on February 1st. This is now false. Um, unless you create a line, which we will discuss later. But as the document is written, there is no line to offer buyer broker compensation anymore. That was the primary change for the 2-1 listing agreement.
Leah, good morning,
Yes.
by the way.
Good
Um,
morning.
so, but it does say that on line 50, it says buyer broker does or does not authorize the listing broker to communicate it. It doesn't say the amount, but it does say whether or not you can communicate that.
Yep,
Right?
yep. So that's a good point of clarification. So there is a line, and I was taking this as there is an amount of compensation to be offering that they are agreeing to, not that they are authorizing, hey, we're willing to compensate, but that there was a specific amount. So that was a good distinction. Thank you for bringing that up.
Oh, and just to clarify too, because I'm having this issue today, I have a couple things I'm probably going to yell at you about. Anyway, um, if they put do not authorize for me, for example, to tell the buyer broker that there's something, it doesn't mean that they couldn't put something in the contract.
Correct.
In
Absolutely. Yeah, that's a great question. So with that, yeah, that one's a little weird for me. I understand why it's there, and honestly, that was kind of one of my suggestions originally. That hey, we need to know from the seller, are you willing to compensate, and if so, give me authorization to say so. But if they say either no, I'm not willing to compensate, or no, you're not authorized to say so, then I think realistically that just needs to be our response back to the buyer's agent. But to your point, that absolutely would not preclude a buyer's agent from including the SCA and submitting that with their offer.
okay, thanks.
Yep. Any other questions about the poll?
No, but now I want to change my answer because I was on the same thought process.
No, I think that's great. I'm glad that somebody else brought that up. You know, when you're writing questions and in your mind, you know the direction of the question and what you want the response to be. So I love it when little nuances are added for consideration. All right, so as we mentioned, this form was updated on February 1st. So when you're using documents, and hopefully all of you are using some form of system, SkySlope Forms or Transaction Desk or something similar, where these are updating automatically for you, so you don't necessarily have to keep track of all this. But if you are somebody who likes to download things to your computer, that's ill-advised, and I wouldn't. But just make sure that you are using the February 2025 version of this. All of the regular disclaimer stuff, and that it says exclusive right to sell, not exclusive agency at the top. The parties, I think that's pretty clear. Okay, the owner or seller, as it appears on the deed. If you are talking to somebody whose name is not on the deed, please make sure that you are confirming that they have the legal authority to enter into this agreement. It might be trust documents, it might be a member of an LLC and their LLC documents. If somebody had passed away, this might be whoever was appointed in essence to handle the estate. So there could be a number of people, but please make sure you're doing some due diligence and possibly consulting with title to ensure that you've got the right person here. Broker, that's going to be the brokerage or firm name, and then agent's name. And we have 2 lines now just in case there are co-agents involved, so you can put both of their names down there. Property, the premises. Owner agrees to sell or rent the real property with all improvements, fixtures, and appurtenances thereon are incidental thereto, plus the personal property described herein, collectively the premises. And we'll get into on the next page, kind of going through what the fixtures and personal property would be. The premises address, the assessor's number, city, county, zip code, and the legal description. Very often, I find that the legal description is left blank. This is a huge problem. Of all of the information regarding the premises that is on this form, the legal description is the most critical because that's the most accurate as far as determining what property is actually being sold. So please make sure that you are not leaving that blank and you are filling it in correctly. Listing price and terms agreement.
sorry.
This res- Oh,
It's
yes.
me again.
Oh, hello, me again.
I should pay attention to the raise hand or something. Sorry. Can you go back? Because
Yes.
my question is what shows on Monsoon and what shows on the actual warranty deed are two different things on my legal description.
Yeah, your warranty deed, if you are willing to go so far, is definitely going to be the most accurate. There are abbreviated versions that are available to Monsoon. The abbreviations will still take the title company to the correct place. But if you want to get really fancy, yeah, you could go through the deed and through the assessor site to gain more information.
Perfect. Thanks.
You're welcome. The residential listing contract exclusive right to sell rent agreement is between owner and listing broker. In consideration of listing broker's agreement to find a ready, willing, and able buyer or tenant, owner gives listing broker the exclusive and irrevocable right to sell and rent the premises described above. So remember in the first poll, we had discussed, hey, you may have an agreement that has just the sell box marked, and you may have an agreement that has just the rent box marked, and that's totally okay if those are different brokers. The problem would potentially be if somebody marked sell and rent, and then we have some conflicting situations that we would have to remedy. Owner acknowledges that signing more than one exclusive right to sell, rent, or other form of listing contract for the same term could expose the owner to liability for additional compensation. So we're putting it right out there. Do not sign more than one of these, especially exclusive rights, because that means that you will owe two brokers. Now, the likelihood of this happening, assuming the listing is going into the MLS, is pretty slim because it's going to flag you that there's an error, there's a problem, and the person who had it signed first is ultimately going to be the prevailing broker for that situation. But there may be wholesale deals or other situations that are off the market and we are not aware of, and this could put the owner in a bind. So during your listing appointment, just make sure they understand that and they have not signed any documents at any point with anybody else. The listing price shall be whatever dollar amount, plus in the case of a rental, all applicable lease or rental transaction privilege taxes or other such price and terms as are accepted by owner. If you have not read the Book of Yes, I strongly recommend it. It is literally a book of scripts, and some of his pricing scripts are my absolute favorite. They're short, sweet, to the point, and I think that they really will resonate with most people, as opposed to kind of fumbling through the whole pricing objection. It really just goes into like, hey, your neighbors have already tested the market and they failed, and here's why. So I love it. Mark it down. It's a good one for you. This agreement shall commence on whatever date and shall expire at 11:59 p.m. Mountain Standard Time on whatever the expiration date is. So again, we're looking to keep those within the 12-month period in most cases. Upon full execution of a contract for sale or lease of the premises, all rights and obligations of this agreement will automatically extend through the date of the actual closing of the sale or lease agreement. So what that means is if you're under contract and you obviously represent the seller, and your close of escrow date is going to be beyond your listing expiration date, you do not have to have a listing expiration date addendum, a sold change form signed, something to that effect. You don't have to extend the expiration date while you're under contract. However, if you don't do that while you're under contract, specifically in the MLS, if you don't get that updated and it doesn't close and you go to put it back to active, it's not going to go back to active if it falls out. It's going to go right into expired. So I would strongly encourage and recommend that you make sure you're staying on top of your paperwork, your timelines, and update them accordingly. But if you have just a really belligerent seller, and it will happen, who absolutely will not sign anything else, like if I have to sell my home, I'll have to sell my home, and I guess you're getting paid for it. But I'm not going to sign to extend anything with you. So hopefully this one works out. Then obviously just know that you are protected in that situation. Owner or any party that owner designates to act on their behalf warrants that they have the legal capacity, full power, and authority to enter into this agreement, deliver marketable title to the premises, and consummate the transaction contemplated hereby. Okay, so we kind of discussed that already. Make sure we know who we're working with. This agreement may be modified only in writing, signed by owner and listing broker. That's such a weird turn of phrase for me. Only in writing, signed by. I mean, I guess maybe only in writing. I don't know. The English major in me thinks that that's kind of a weird sentence, but it is what it is. The moral of the story is that you ultimately have to have some sort of addendum or form to modify any of these terms. You cannot do that unilaterally.
Leah, I have a question for you.
Yes.
So on line 21, I always get tripped up on this. This
Yeah.
term, this agreement shall commence on this date. But then when you go to put it in the MLS, like use the profile sheet and all that, and maybe other agents do it differently, you know, the day that it goes on the market is not necessarily that. And then you get dinged in SkySlope because the dates don't match up.
Yeah, so there's two parts to that, Robin. So thank you for bringing that up. One, is anybody from Armless on this call? Because I'm going to tell you a Leah response to something, not a broker response. And I want to make sure that I don't get flagged for it. So if you are an Armless person working for Armless, please raise your hand and let me know and exit quietly. So the first part of that is my commencement date would always be the day that I am getting this listing agreement signed. Okay, I'm not looking to open up an opportunity where another agent could swoop in, get something signed prior to or an earlier commencement date, and now we have conflicting documents and potentially a problem for who legally represents them. So my commencement date is always the day they are signing. From that means for Realty One Group agents, and most brokers have something similar, you need to upload this document within 3 days of it being signed, no matter what that commencement date is. So within 3 days of getting signatures, we need this uploaded into SkySlope. However, the date that you input as your start or commencement date in the MLS is the date that I put it into the MLS. So in essence, if I took this listing and it commenced a month ago, it was signed a month ago, and I'm now putting it into the MLS, I am not going to put my start date a month ago. I'm going to put my start date on the MLS as today. That way the days on market, both cumulative and agent, will reflect 0 days on market. Anything else is a detriment to my seller. So that's how I'm going to play that game. It is always okay, at least for Realty One Group, if your listing start date on the MLS is after your commencement date. For obvious reasons, it just can't be before. If you put it on the MLS before this commencement date, you did not have legal authorization from your seller to do so. So I know that was a few things, Robin. Did that answer your question and probably more than you wanted?
No, that's what I do. But, I get dinged on SkySlope and they say, that my listing date on MLS doesn't match my listing agreement. And I'm like, well, of course it doesn't, because I'm never putting it in the MLS on the same day that I get the listing agreement. So
let me know the next time that happens. I will go ahead and let our head of compliance know that as well. It's different for an expiration date. Now, your expiration dates must match exactly. So this is only referring to the start date. So
correct.
If you're starting late and changing the expiration date, that would be a different story. But yeah, the start date can always be later. That does not have to match. Reach out to me afterwards because I'll make sure that your document reviewer knows.
Leah, may I say something?
Of course.
What I usually do if the listing is not going into the MLS, right away, I put in the extra remarks, whatever that section is, that seller will let Realty One Group, me, Bonnie Samita, know when the house is to go active on the market. And then, so if the compliance department for Realty One Group reads that, then they know.
Yeah, no, that's a great point. And I actually have that. I have a final slide here that has some clauses, and that one's actually on there. So that's definitely helpful as well.
Mm-hmm.
Me again.
Hello.
All right. So Also, when you enter in MLS now, I'm still SVVAR. Sedona's still you separate. We're not part of Armless yet, but we'll be on May 1st. But there's a choice in exclusive authorization or exclusive agency. And I thought exclusive agency opened you up to having other people list it versus exclusive authorization. And so that's been confusing for me.
Yeah, and I'm not familiar, obviously, with how their MLS inputs are. For me, exclusive authorization would be this exclusive right to sell rent, and exclusive agency is exclusive agency. Is there something potentially different?
Well, yeah. So, um, because the exclusive right to sell doesn't tell me whether, okay, exclusive agency is different by exclusive authorization in that agency opens you up to others and authorization allows you to be really exclusive. I guess it's the exclusive part at the beginning I'm confused with.
Yeah, so like I said, I'm not familiar with exclusive authorization, so you'd have to, I guess, chat with up there with Sedona to kind of figure out how they're redefining that.
Okay,
Exclusive
so it'll
agency,
probably be fixed when we get to be part of Armless. In Armless, it says exclusive agency.
yeah, it's going to say exclusive right or EA or ER. Which one are you using? So exclusive right or exclusive agency?
Okay, got it. All right, thank you.
No problem. All right, equal housing opportunity. Listing broker and owner shall comply with all federal, state, and local fair housing laws and regulations, including but not limited to non-discrimination based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. So we are putting it right out there. One of my favorite phrases that I learned in a fair housing class is when you're discussing with this with your seller, you tell them, as far as we're concerned, everyone is green. Okay, so that's all we care about is their ability, financial capability of closing this home. Nothing else matters. So please make sure that they understand that because they make a comment regarding an unwillingness to sell to a certain person, we are going to stop the listing and we are going to cancel and be done with them. So it's a problem. Make sure that they're abiding by that law accordingly. All right, everybody's favorite part, compensation. For those of you who previously took some of the new forms classes with me last year, you know how I love my eggplants as reference. So they're making a comeback on this page. So in big, bold, capital letters, listing broker compensation is not set by law nor by any board, association of realtors, multiple listing service, or in any manner other than as fully negotiated between listing broker and owner in this agreement. Should the owner choose to offer compensation to a buyer broker or tenant broker, the offered amount is also fully negotiable and agreed upon after discussion with the listing broker, and initials are required there. Of course, this has always been the case, but now we have to draw extra attention to it due to the requirements in the NAR settlement. You wouldn't think this is a problem, but it has been, especially based on the strength of dollars in, well, whatever their currency form is in other countries. But all funds are to be in US currency. We're not negotiating that. Owner agrees to compensate listing broker and other broker, if any, as follows. Retainer fee. Owner agrees to pay listing broker a non-refundable retainer fee in the amount of however many dollars within 5 days or however many days of execution of this agreement, which is earned when paid for initial consultation, research, and other services. This fee shall or shall not be credited against the listing broker compensation. I'd say fewer than 1% of the listing agreements that I see in review include a retainer fee. Where we most often see this is in the luxury market, and I can understand that. So, in essence, the seller is compensating the broker upfront for specifically some of their marketing fees. If they're going to do high-end photos and staging and videography, things of that sort, there's a good chance that the listing agent is going to be exhausting quite a bit of upfront money, and they want to make sure that they are not going to lose out on those funds should the deal cancel for some reason in the future. So that's, like I said, when we most often see it, but you're all welcome to charge what you want if you want. Just make sure that that fee is payable to your broker. It is not something that goes directly to you, and there may be brokerage fees that apply to that. So just have all of those details before you do it. And then obviously if it's credited or not credited. So this may be in addition to whatever we're going to put on line 46, or it may be subtracted from line 46 at close of escrow. Listing broker compensation. If listing broker produces a ready, willing, and able buyer or tenant in accordance with this agreement, or if a sale or rental of the premises is made by owner through any other broker or otherwise during the term of this agreement, owner agrees to pay listing broker compensation of whatever that percentage or dollar amount is going to be. So that's where you're going to go ahead. This is listing broker compensation only. So whatever amount you are charging, that is the amount that you will put on line 46. Additional listing broker compensation. Unrepresented buyer. Okay, I'm going to preface this with, I would strongly encourage all of you to have something on this line. Unrepresented buyers are becoming far more common, which we suspected would be the case because they've been misinformed as to how the new rules work as far as getting representation for a transaction. And they believe that they can save money or that they wouldn't have to pay a buyer broker if they go this route directly through the listing agent. So make sure that you're prepared for that. That being said, unrepresented buyers can be a lot of work. While you're not representing their interests, you are representing your seller. So you have to do everything necessary to facilitate a deal. So you're in essence doing double the work. Don't shortcut yourself on what compensation may be entitled in that situation. So owner agrees to pay listing broker additional compensation of whatever percent of the full purchase price or however many dollars if the buyer of the premises is not represented by a buyer broker. Up to you how you want to handle this. One of the things that I've actually been talking to several of my agents about is that they may want to make that amount consistent with what they would be asking for or charging if they were to also be a dual agent. You know, what would they be charging that buyer broker so that they could react accordingly? Here's the reason for this, because I know that sounds a little convoluted. We've had situations where we had one number on the unrepresented buyer line, and then we had a buyer approach us who wanted to be represented. So instead of having an unrepresented buyer, our listing agent is now serving as a dual agent on the deal. And when the agent submitted the SCA as part of their buyer's offer to their seller, it was a higher amount than what was listed here in the listing agreement. And the sellers couldn't disassociate or didn't understand, they couldn't make the distinction between what is an unrepresented buyer and what is a represented buyer where my agent is representing them as a dual agent. So they didn't understand why one amount would be different than the other. They just remember seeing these two numbers on their listing agreement, and they were really digging their feet in that they weren't going to pay more. This is really more just a strategy conversation. I'm not telling you do one thing or do another, ultimately just something for consideration. We have bumped into that a couple of times now. So your pricing or your compensation may want to be consistent with whatever you would likely charge a buyer broker in the case of a dual agency deal. Buyer broker, owner does or does not, so this is what Leah was referencing, authorize listing broker to communicate owner's willingness to potentially compensate a prospective buyer broker depending on the terms of the purchase offer. Requests for compensation should be set forth in the prospective buyer's offer to purchase the premises. So really, we just want to know, Mr. and Mrs. Seller, are you willing to entertain paying compensation to a buyer broker? Yes or no? Okay, if no, then obviously that's easy enough. We would say does not, because there is no willingness to potentially compensate. If they are, however, then we would go ahead and say, okay, let's mark does, assuming I am okay to share that. I've never had a seller push back on that. If they are willing to negotiate that, they're willing to potentially pay something to a buyer broker. I don't know why they wouldn't want that to be communicated. I suspect that that will help ensure more showings, whether that's what it should be doing or not, than saying, yeah, no, I'm not at liberty to share that information, or I'm not authorized to let you know if my seller is willing to compensate or not. So I suspect, unless their answer is flat out, no, I absolutely will not compensate a buyer broker, that the majority of sellers are going to have the does box marked in this situation. Questions so far on that? That was a lot that we just covered, and this was the main change.
So that is my issue, right? Even though as soon as we sell the house, we've already looked at places that they want to buy, and I'm like, well, you guys are going to have to pay me on then if you're not willing to compensate a buyer broker, then when we go to look at houses after your house sells, are you willing, and I already have a buyer broker signed with them. So it's interesting. They're just really bent on not paying the listing broker. I mean, the buyer broker. And I've given them every single reason to think that it's important. I mean, I have the list, but, anyway, I at this point am
Just it's not. Yeah, there unfortunately, there's just nothing you can do in that case, and we've had a couple of sellers that were absolutely bent on this, and they refused to even consider it, and it's just crazy to me, right? Because I'll give some extreme example. I'm like, so let me understand this. If we have an agent or if we have a buyer who comes in paying cash and they're willing to go over list price to help ensure that their agent is compensated, you're still going to say no. Now, in that case, of course, if they're cash, they could just pay their own agent and it wouldn't even be a deal. But
right.
ultimately, I know we have all of these scripts to utilize, but sometimes they can't get out of their own way.
Yes. Okay. Thanks.
Anything else?
Leah, I have one question. This is Jenny.
Yeah, hi.
Hey, so can you kind of just touch on the legal portion of like what I know we can't go through the arm list to tell other agents, hey, my seller is offering XYZ. Can you give me some ideas on how to advertise that otherwise in
Yeah, so
the house?
yeah, so there's actually remind me, Jenny, shoot me an email and I'll send you what I sent out. So I actually have a graphic that shows all the places where you can, but bear in mind right now this part of the ER is only saying yes, they're willing to offer something. I'll get into if they want to designate a very specific amount. That is not my recommendation, which means other than indicating on marketing, hey, they're willing to compensate a buyer broker, you're not designating a specific dollar amount or percentage to that. But yes, I actually have a chart, and that goes for anybody. If you email me, I'll send you a copy of that little graphic that I've designed for where you can share that your seller is willing to compensate a buyer broker.
Great. I will email you. Thanks, Leah.
No problem. Right. Owner acknowledges that buyer broker represents the interest of the buyers and not the interest of owner in a transaction unless the agents of listing broker represent both owner and buyer under limited representation as described in section 6. Owner also acknowledges that the buyer broker may credit part or all of their compensation to the buyer. Okay, so that's just giving them a heads up that ultimately, let's say that the buyer broker has a buyer broker for 2.5%. But strategically, they decide that they and their buyer decide that they are going to submit a seller compensation addendum for 3%. So as our agreements are written, that leftover 0.5%, that difference of 0.5%, would be credited to the buyer at close of escrow. So this is just notifying the seller that that may occur so they can't start freaking out if they see the credit on the settlement statement at the end of the day. It's all legit and they agree to it up front. Then it's all the same stuff for rentals. So we're not going to go through all of that. It's the same verbiage all the way down, with the exception of then getting to 70 if you are doing rentals, the rental renewal or extension. If you are doing rentals, I'd encourage you to consider this. We've had some people graciously paid, I mean, and I do say graciously because nothing was in here, but their landlord just thought it was the right thing to do when there was a renewal. After the initial lease expired, but just a good time to maybe put a couple bucks in there to help compensate you for doing it in the first place. If during the terms of any rental of the premises, including any holdovers, renewals or holdovers, or within days after the rental's termination, any tenant or his heirs, executors, or assigns shall buy the premises from owner, the sale compensation described in section 4 shall be deemed earned by and payable to listing broker. So really, this is a little bit redundant, right? Because we've already said, hey, should the property sell to anyone for any reason during the term of our agreement, I, the listing agent / broker, am entitled to compensation. So it's just reiterating that that also applies to tenants and everyone under them. In the event a dispute arises between listing broker and any other brokers regarding payment of compensation, owner shall not revoke or seek to amend compensation previously offered. Any compensation dispute between brokers shall be resolved after the close of escrow in accordance with the realtor's dispute resolution system or as otherwise agreed. Probably unlikely. I mean, usually by the time that brokers are getting involved, we have all of the necessary documentation to support who's owed compensation and why. This could potentially be a concern with rentals if you don't handle compensation a certain way. Unless you have a property management division that can collect checks a little differently, just a little piece of advice I would give when you have the tenant bringing in their deposits, rents, and all of that before they get the keys to the property, have them split that into 2 cashier's checks. So the one would go obviously to the landlord, but the second one would go to us, the listing broker, for the compensation for both parties, if applicable. So that way we're not giving all the money to the landlord and waiting for the landlord to cut a check back to the broker. And by the way, we've had situations where the landlord, after all that, did not cut a check back to the broker, and the broker had to pay the tenant's broker directly without having any money. We had to pay out of our own pocket. So if you have the compensation deducted from the total deposits and rents that would be due from the tenant when it comes time to get their keys, then you'll already have that check ready to go, that cashier's check ready to go, so you don't have to deal with that down the road. Withdrawn or canceled listings, the same amount of sale or rental compensation shall be due and payable to listing broker if, without the consent of listing broker, the premises is withdrawn from this agreement, otherwise withdrawn from sale or rental, or is rented, transferred, or conveyed by owner through any other broker or otherwise. So that sounds a little more convoluted than it needs to, but again, at the end of the day, one, I don't know how we wouldn't know unless they're doing something really underhanded. Usually they're notifying us that that's what they intend, but they're not canceling a listing without our agreement because it's a bilateral contract. So ultimately, if they try to get sneaky and sell it out from under us, though, we're still going to be entitled to compensation. Payment from escrow or rent. Owner instructs the escrow company, if any, to pay all such compensation to listing broker by check, wire transfer, or certified funds as a condition to closing, or upon cancellation of the escrow, and irrevocably assigns to listing broker, to the extent necessary, money payable to owner at the closing or cancellation of escrow. The reason that cancellation of escrow is in there is for the 2 little hearts that you see down at the bottom. So we'll cover that in a minute, but keep that in mind. Listing broker is authorized to deduct compensation owed to listing broker from any rent or other monies received by listing broker on owner's behalf, which is what we just kind of discussed, where that would be my best practice, is have that all taken care of at the onset of the tenant taking over occupancy for the property.
But so I have this client is an attorney. Okay. He used to be the
Of
city
course
attorney
they
for the-
are. Yeah.
And he wants me to make changes in this all over this contract. But this actually, because of the cancellation, he's freaking out because he thinks that we'll be able to keep his earnest money.
So if earnest money is forfeited, we are entitled to half. So, I mean, he's not totally incorrect. Now, that being said, that's discretionary. So we as the broker, let me put it this way, are not pursuing sellers for half of the earnest money. This is really at the listing agent's discretion if that's something that they want to have upheld or not. There are certainly circumstances in which I would do that. The primary being if I know for a fact that the seller is not going to continue their listing with me, that they're done for whatever reason, and this buyer canceling is just, the icing on the cake, then yeah, I'm to try to help compensate me for my time and effort. I am probably going to uphold the part of the agreement that says, hey, I'm entitled to 50% of the earnest money. In the very, very rare case that earnest money is even forfeited to the seller. I mean, let's start there. The likelihood of that happening is slim to none.
Leah, I have a
Right, it's
question
not
for you.
his-
Oh,
Thank you. That's okay.
yeah.
Okay, so just going back a bit, on line 73, purchased by tenant, I know it referenced it. You said described in section 4, typically there's a space there for the amount of days, and I don't see that line anymore. Should there be a line in front of days on line 74?
No, so the only line with days is gonna be in the after expiration clause. So I mean, they're gonna hold their feet to the fire even if, because, and again, this is only during the term of your agreement. Now, the term of your agreement may also include your after expiration clause, but that's all that this is going to include. So we didn't need a separate line specifically related to tenants because the other terms already cover that.
Okay, so if during the terms of any rental of the premises, including any renewals or holdovers, or within days after the rental's termination, how many days? Like, it doesn't let you put anything there.
I see what you're saying. Yeah. I think that they were just going to based on whatever the after expiration clause is. But no, that's a good point, Robin, that ultimately there should be something there if that's going to be different than what they are already accounting for. Let me make a note of that and I'll let AAR know and see if there was a reason that they kind of modified that. I was just interpreting it that, okay, we're going to actually have our term days incorporated into that.
Yeah, I think the previous ER had a number of days in there because I would always put 60 days or something, or 90
Gotcha.
days, whatever. So,
Yes. Yeah, exactly. For whatever it is specific to the rental term, not just accounting for the actual listing duration.
correct. Thank you.
Thank you. Good catch. Any other questions so far? Okay, let's go to after expiration. So after the expiration of this agreement, the same compensation as appropriate shall be payable if a sale or rental is made by owner to any person to whom the premises has been shown or with whom owner or any broker has negotiated concerning the premises during the term of this agreement, with the caveats, within however many days after the expiration of this agreement, unless the premises has been listed on an exclusive basis with another broker, during the pendency, including the closing of any purchase contract or escrow relating to the premises that was executed or opened during the term of this agreement, or as contemplated by Section 4. Okay, so we've covered that stuff. So however many days after expiration, the most common I see is 60, but obviously you can do, whatever, 15, 30, 90, 120. The reason this exists is so that ultimately a buyer and seller don't get together behind your back and where the seller says, hey, I know you're interested. My listing agreement is going to end next week. Come back after that, and then let's go ahead and do this without our agents involved so that we can both save a little money. That is the reason that they designed this clause in the first place. So understand that this will not apply if they relist their house with another agent. So even if a buyer came to look at the house 3 or 4 times while you had it listed, but they never submitted an offer, your listing expires, and ultimately that buyer comes back 2 days after yours expires, but the seller's already listed with another agent, you're out. You're not entitled to anything. So assuming that they had their own agent, now you could be entitled to something on the buyer side if ultimately you're representing them and you submit an SCA and all that good stuff. But this is assuming, no, they looked at it with their own agent. They're coming back. You're just not entitled to anything because the seller listed with another broker prior to that offer being received. This does lead me to a what would Leah do? And I don't ever suggest canceling a listing because if you cancel, that is actually different than expiring it. Okay, so you don't have an after expiration clause in play. If you didn't let it expire, you canceled it. Cancellation is final. There's no longer a commitment there. So if you are in a situation where you are being asked to cancel a listing and you generally agree with doing that, don't cancel it. Just change the expiration date to a sooner date. So if your seller is trying to get away with something, you at least have some layer of protection involved here. If completion of a sale or rental is prevented by default of owner or with the consent of owner, the entire sale or rental compensation as appropriate shall be paid to listing broker by owner. Okay, this is in essence, if the specifically if the sellers get sued for specific performance. So we're all the way up to close of escrow. Please bear in mind, you're not entitled to compensation. If ultimately the sellers decide that they're going to have a change of heart, they're going to take the home off the market, they want you to cancel, expired early, whatever the case may be, because you've received an offer. You're not entitled to compensation at the point where you've just received an offer. The buyer literally has to go all the way up to the closing date, and they have signed, sealed, delivered. They are ready to go. And at that point, our seller pulls the plug. If they do that, then you are entitled to compensation, which is a lawsuit. Well, ADR, which we'll go through, but then a lawsuit. So just kind of buckle up and be ready for that if the need arises. At that point, generally speaking, the other broker is also getting involved, and they are filing, and the buyer is filing a specific performance lawsuit against the seller as well. So there might be a lot going on, and obviously these are the things that we caution our seller about if they think they want to pull the plug at the end of the day. And then the second part of this, so if any earnest deposit is forfeited for any other reason, okay, so this would be buyer breach, owner shall pay a brokerage fee equal to the lesser of 1/2 of the earnest deposit or the full amount of the compensation. So depending on what you're listing, I suppose if it's land, the half of the earnest money could actually be more. But generally speaking, it's going to be the lesser, which would be the 1/2 of the earnest deposit. So make sure that not only are you informing your sellers why it's appropriate and in their best interest to ultimately have a high enough earnest money amount that it will cover their bills at half, because half of it's going to the listing broker. So if they're thinking, oh, well, $2,000 would cover, a month of all my bills, then realistically, they should be looking for earnest money that is at least $4,000 to help offset that. Now, again, the likelihood of a buyer forfeiting their earnest money is slim to none, but on the occasion that it happens, you do have this little ace in your pocket. Ideally, like I said, if I were the listing agent, I'm not charging this. If my seller is going to continue to work with me, I'm not going to uphold this part of the clause. This would only be if the seller is so irritated by the way things have gone, and I know that they're going to push to cancel the listing or at least take it off the market, or they're going to be a problem. Then I would go ahead and take what I could to try to make up for my lost income at that point. Construction. To the maximum extent permitted by applicable law, this agreement shall be construed as limiting applicable provisions of law relating to when compensation is earned or payable. In the event of any express disagreement between any provision of this agreement and the requirements of applicable law, the applicable provision of this agreement shall be deemed as modified to the minimum extent necessary to ensure compliance with applicable law. I don't know which one of our AAR attorneys wrote that clause, but good God. You can tell that's definitely where that came from. So we'll have to, I don't know if that was Rick, Scott, somebody deserves maybe a slap on the back. Ultimately, it's just saying, hey, if there is law associated with any of these provisions, that the higher level of the law is going to be what prevails, specifically related to compensation and when it's earned and payable. And a lot of that comes from case law. So we really didn't need to make it that complicated.
My attorney client here is telling me, he thinks that, again, because he's an attorney, thinks it impinges on the rights. And, how come it just can't be controlled by the existing law?
That's all I needed to say, right? I mean, I don't disagree with him then. I'm like, I don't know what the mindset was behind that, but that's a very convoluted way to get to a very specific point, in my opinion.
Right. So if he wants me to strike that because it bothers him, can we put that in the instructions?
You can, but make sure that you're clearing that with your broker before doing
With
that.
Kathy. Okay.
Yeah. For me, yes, I'd probably be willing to strike this only in the situation that I don't think it would even come to pass where it would be a problem, but we'd want to make sure that the agent was fully aware as to what they were potentially giving up. Not so much us. Yeah.
All right. Thank you.
No problem. Anything else on this page? Okay. We're all good on the WWLD? Let's take a poll. Maybe. I don't know that I shared the results originally. I got to get better about that. Okay. Poll 2. True or false? A Ring doorbell is a fixture which conveys to the buyer. True or false? A listing broker must have written permission from their seller to disclose material latent defects to prospective buyers. True or false? A listing broker must disclose to a seller that they are listing an identical floor plan on the same street. And, oh, I created a story. Listing agent Leah works for Realty One Group. Her seller receives an offer from buyer agent Bill, who also works for Realty One Group. When her sellers ask for her opinion about the offer terms, Leah replies, I would counter them at $850,000. Is this an agency violation? I try to make it easy by doing a whole bunch of true or false. Five seconds. Okay, I'm going to end the poll and then I'll share the results in a second. But I want to hit, it looks like I had a couple of questions in the chat. Let me hit on those real quickly. So, Jessica, lines 50 to 52, does this eliminate the additional clause you had previously recommended? Yes, it does. So, you no longer have to utilize that clause, and I've actually removed it from my clauses forms. How do we cover ourselves on the dual agency issue? Linda, if you can unmute yourself and get me more clarification on what you're asking there. I'm not sure I understand the question. Yep, in the reload. Thanks, Jules, for sharing that. I agree that that's helpful.
Somehow I don't have any volume.
All right, true or false? A Ring doorbell is a fixture which conveys to the buyer. That is true. All smart home devices, including video recording devices, are considered fixtures. True or false? A listing broker must have written permission from their seller to disclose material latent defects to prospective buyers. Congratulations. Yes, that is false. They are already indicating that, and by law, we must comply with that. So if we are aware of something, we have to be sure that we are notifying prospective buyers if our sellers are not already doing so on their spuds. True or false? A listing broker must disclose to a seller that they are listing an identical floor plan on the same street. Also false. That is correct. They reserve the right to do so. Listing agent Leah works for Realty One Group. Her seller receives an offer from buyer agent Bill, who also works for Realty One Group. When her sellers ask for her opinion about the offer terms, Leah replies, I would counter them at $850,000. Is this an agency violation? The majority of you said yes, which I'm going to say is correct unless somebody who gave maybe wants to unmute themselves and say, why is it a maybe? I have an idea why it could be a maybe, and I'm curious if that's what you're thinking or you just don't know and maybe seemed like a safe choice.
Because that's a Leah answer and you threw it in to throw us off.
So it's not just Realty One Group, right? There are other Realty One Group offices that are not under the same designated broker. So the caveat, with one exception that I'm not going to get into, the caveat is in essence that you work for the same designated broker. So our folks up north or in Yuma or Tucson, for example, that work for different Realty One Group franchises, that is not a dual agency limited representation situation. Same goes for other brokerages who might be on the call. If you're all under the same designated broker, then this would be an agency violation. You cannot advise or give suggestions as to counter terms or terms willing to accept. So that I'm going to stick with primarily, yes, this would be a violation if it's under the same designated broker. All right, let's get into this one. Fixtures and personal property. For purposes of this agreement, fixtures shall mean property attached or affixed to the premises. Owner agrees that all existing fixtures on the premises, personal property specified herein, and means to operate fixtures and property like fan remotes shall convey in this sale or rental, including the following. And then there's a long list. I'm not going to go through all of these. You can see on line 110 there, the smart home devices, access to which shall be transferred, like a video doorbell, which would be a Ring doorbell. So that's already indicating, and hey, seller and buyer, well, this is reiterated on the purchase contract, hence me saying buyer. But for the seller side, they need to do whatever is necessary to transfer that access, which might be doing something on the backside of their account, just a heads up. Make sure that you are going through this line by line and asking if there's anything on this list which they will not want to convey. Because if that is the case, we either need to remove it now, which is ideal, or mark it in some way, have a sticker on it that it does not convey. But the bigger part is making sure in the purchase contract that it's specified that something does not convey. Otherwise, it does. If owned by owner, oh yeah.
Sorry, a quick question about this. Hi, it's Nicole. If the seller does not follow through by transferring those accounts over, is there anything the buyer can do? Like I've had a situation where they didn't transfer over the accounts to like the Google Nest cameras and things like that. So what is your best recommendation for that kind of situation?
Yeah, so twofold. I know that this is a challenge, right? Because technically, while most things have to be done 3 days prior to close of escrow, as a seller, I don't know that I'm going to be handing over access to all of my security stuff that soon in advance. But I would imagine if we're like a day before closing and that hasn't been done, I would cure them for it. Ultimately, see if we can give them the opportunity to perform. Outside of that, the buyers are probably going to have to take on the onus here, which means they're going to have to get in contact with the provider. And they're going to have to show like their settlement statement indicating they now own that address and try to get the provider to work with them.
Okay, thanks. I love the tip about doing it 1 day prior to close to cure them. That's great.
I try my best. Sometimes that's at least we have a paper trail. Right now, this isn't something to hold up closing over. It's not a material
Right.
arrangement contract. It's immaterial. But at the same time, yeah, just something we can do to light a fire to try to get this remedied.
Yes, exactly. Thank you so much.
Yeah, no problem. If owned by owner, the following items are also included in the sale or rental. Okay, so that's the critical part. If owned, if they are not owned, they need to disclose that. There's a place for that on the spuds. Ideally, we would know about this as well. Solar being the big one because we're going to need a solar addendum, of course. But other things that may not be owned: water softeners, purification systems, security systems, and in-ground pool and spa hot tub equipment and covers. I gotta tell you, that's the weirdest thing. And obviously, this has happened, and that's why it's in our agreement. Like in-ground pool and spa equipment, like literally, you can rent maybe some special type of vacuum. I don't know what that looks like. I'm West Valley, and I'm not nearly bougie enough to understand what could possibly be worth renting to stick in my pool or hot tub. But I assume something exists, so I guess verify that. Additional existing personal property, which may be included in the sale if checked. So the maybe obviously is that that's going to be referenced on the purchase contract, that it's something that the buyer wants and asks for it. So try to give some sort of description. Yes, I understand serial numbers are best. Maybe it's feasible, maybe it's not. But, stainless steel side-by-side refrigerator, whirlpool in kitchen. Just some sort of description for all of those items. And in case you didn't know, an above ground spa or hot tub and all of its stuff is considered personal property. So just make sure that the sellers are aware of that. Now, I know we've had some people move them. God, I don't know why. Like there's cranes involved. You can damage it if you try to turn it onto its side after it's previously had water running through it. Yes, I know that there are people who specialize in moving these things, but why? Leave it with the house. But just make sure that we're aware again so we can handle it accordingly when the time comes on offers. Additional items of personal property, which may be included in the sale or rental. We personally had a really big, really heavy pool table on the second floor of our house. We were not taking that sucker. So we referenced it here and we told the buyer they had to keep it if they wanted the house. So again, it may just appear on 2 different locations, but that's a spot to put stuff. The following items are leased or not owned. So they're going to mark those things here, but then they're also going to reiterate that in their spuds. Other leased or lien items not included in the sale or rental, and then fixtures not included in the sale or rental, so that we can go ahead and we can indicate that on the MLS and make sure that that's appropriately reflected on any offers we receive. All right, before I get into agency, any questions about fixtures and personal property? All right. Listing broker shall represent owner in any resulting transaction during the term of this agreement, except as specified in Section 4. Unless otherwise agreed, listing broker acts as owner's agent only and has the duties of loyalty, obedience, disclosure, confidentiality, and accounting, your fiduciary duties, as well as other duties imposed by the Arizona Department of Real Estate. Owner acknowledges that listing broker may show prospective buyers the premises, and this shall not constitute a conflict of interest. So right off the bat, we're already indicating that, hey, dual agency, limited representation specific to just me as the listing agent may occur. They are aware of that. They are aware of what their fiduciary duties to them owed are, and ultimately that they are saying yay or nay to that. Let me get to the second part and then I'll cover something that I want to make sure is covered. Regardless of whom they represent, all brokers have the obligation to treat all parties to a transaction fairly, disclose in writing all facts known to the licensee that may materially and adversely affect the consideration to be paid for the premises, and disclose that owner or buyers may be unable to perform. Realtors are further obligated by the National Association of Realtors Code of Ethics to treat all parties honestly. So it's just kind of breaking it out. No matter what, these are, again, duties is probably the wrong word, but these are all of the things that are owed to you and to the other side. So we need to make sure everybody's on board with that. More discussion about limited representation. A limited agency may occur when listing broker procures a buyer for the premises. In this situation, the same real estate company may represent the owner's interest and the buyer's interest, but not to the detriment of the other party. Now, defining that has been a little bit of a trick, right? Listing broker can legally represent both parties with the knowledge and prior written consent of both parties. I have a feeling that if this was more often explained to our clients, they may not be so willing to engage in limited representation. So I'm glad that our most recent versions of the listing contract have actually gone into specifics of what a listing broker can and cannot do in a limited representation situation, which is what we're going to go cover. If after going through this, you have a seller who very adamantly says, absolutely not, I want you only to represent me, your advice is so valuable to me that I am willing to forego 3,000 other agents looking at or bringing buyers to my property, because I want to be sure that ultimately you tell me exactly what I need to do. Now, I'm being a little facetious here, right? But ultimately, that's what they're telling me. So I'm going to go to the extreme when I'm talking to sellers to let them know that is the exchange. If you think that my opinion, not facts and figures, but my opinion as your listing agent is so valuable, thank you. However, let me tell you what you're going to give up should you not elect to allow limited representation. And I know that this is not happening that often, or that ultimately sellers are not going down this path, because you would have to have a note in the MLS warning other Realty One Group, in our case, but whoever your brokerage is, you would have to have a note that indicates, hey, people from my same brokerage, don't bother showing because we will not entertain offers with limited representation involved. Has anybody ever seen that written into the private or semi-private remarks on the MLS? One, there might be others. I can only see Maria. One time, two times, once. Yeah. 20 years, I've never personally seen it. I don't know how many thousands of homes, tens of thousands of homes I've viewed in the MLS. So it could happen, but it's very rare, but understand that's the reason why if you see it. So getting into the details, what listing broker cannot disclose to clients under limited representation? Confidential information the listing broker may know about a client without the client's express consent. Sometimes they'll give it to you. Like, sure, tell them we're getting divorced. Tell them that I need to move out because I have cancer, whether it's to elicit sympathy or understanding that the other side might use that as leverage. But there have been times where clients give the go-ahead in writing, like, yes, it's fine to go ahead and share this. The price or terms the owner will take other than the price meaning the list price, without permission of the owner. Same thing. They're like, hey, you know what? go ahead and tell them, I'd accept $10,000 less if we can make this happen within the week. Sure, that's fine. The price or terms the buyer is willing to pay without permission of the buyers. Even chances are, as a listing agent, you don't know that. But if it happens to come up in conversation with the other agent, you cannot let the seller know without permission of the buyer or from the buyer. A recommended or suggested price or terms the buyer should offer. So, again, what is my advice worth from a buyer's agent perspective? And a recommended or suggested price or terms the owner should counter with or accept. So it's really kind of breaking it down. Now, there's others as you kind of get into it. Realistically, from a limited representation perspective, I shouldn't be telling my clients either side, what they should be asking for or what they should be offering as far as repair negotiations. That falls under the same thing, that these are terms that the owner needs to decide. Now, obviously, they have other resources that they can go to. What's critical? I'll just offer money instead, which FYI is always my recommendation to sellers. I'm one of those who thinks it's the easiest, smoothest way for everybody to not have to deal with problems after the fact. So don't agree to repairs, throw money at it. So it's laying it out there. So again, just get their buy-in and make sure that they understand what they are giving up and what they are getting in exchange. Competing owner. Owner understands that listing broker may have or obtain listings on other properties and that potential buyers may consider, make offers on, or purchase through listing broker property the same as or similar to owner's premises. Owner consents to listing broker's representation of owners and buyers of other properties before, during, and upon expiration of this agreement. It could happen for some of you who specialize in neighborhoods, especially. You could have 3 or 4 listings of the exact same floor plan, but they're all a little different. And maybe one of them goes under contract right away and others don't. And it's just that the buyer found that one and decided to proceed. But you're already giving notice, hey, you understand this. We don't need your permission. It could potentially happen. All right, questions?
Question.
Yeah, please.
So one of the hurdles that I am having in being able to go over both the purchase contract and the listing agreement with my clients is understanding giving the information to them, right? Because you have some people who really want all the information. They want you to go line by line, and you have others who want to summarize it. For the ones that want to go line by line, that's fine. I can do that. That's not an issue. My issue is summarizing for those that don't have that capacity to repair. I just can't seem to figure out how to do that because I feel like all that information is so important.
So my best recommendation always is take as many classes as you possibly can, but more importantly, read the documents and then write your own summary line on next to them so that when you're going through, you start memorizing, okay, this is the general gist of this when I'm covering these clause by clause or section by section. And some of them are going to be very brief. So ultimately, we'll get into one of them, but all of your duties and responsibilities as the seller, I'm probably just going to go through, these are the bold things that you need to be aware of. But yeah, this isn't, that's just something that agent by agent, you'll have to get familiar with. And really the only way to do that is to read and know the contract yourself, start making notes in your sideline so that you have a 1-sentence synopsis of each clause or section, and then memorize what those are so you can present it accordingly.
Okay, thank you.
All right, let's go ahead and launch poll number 3. True or false, if a seller gives written instructions to the listing broker to keep their property in active status on the MLS, despite having accepted an offer, the broker must follow the seller's instructions. True or false, a seller can market their home for sale however and whenever they want without permission from their listing broker. I took it easy on you guys with just the 2. Three seconds. All right, let's see what we got here. True or false, if a seller gives written instructions to the listing broker to keep their property in active status on the MLS despite having accepted an offer, the broker must follow the seller's instructions. Correct. That is false. You have these little things called armless rules and regulations to which you must abide. So at the end of the day, the seller is not going to be able to supersede that. You have to change the status to either under contract accepting backups, the stupid contingency backup option, the CCBS, or you're pending. That's it. You can't keep it inactive. It doesn't matter what the seller tells you. And true or false, a seller can market their home for sale however and whenever they want without permission from their listing broker. That is also false, which I don't know that all clearly. I suspected that one would be relatively split. So I'll show you where in the listing agreement that's actually covered. All right, so broker authority, listing broker's role. Listing broker is not responsible for the custody or condition of the premises or its management except under separate contract. Upkeep except under separate contract. Let me change that. Upkeep or repair. So ultimately, it is not your job to go over and clean up the yard or make sure that chemicals are in the pool. I understand that some of you feel inclined to do so, especially if the home is vacant or your clients don't live here part or all of the time. And you think that's part of your listing services to make sure that it's in show ready condition all the time. But it is not your role. And be cautious about what you're doing. While doing a couple things for the sake of, let's say, staging or curb appeal are probably okay. If you start overseeing repairs and handling contractors and things like that, you're probably stepping into property management, which is a violation unless you have a property management agreement. So just be cautious about what you're doing. If you have questions, ask your broker if a specific something is allowed to be done.
I can share that this got me in huge trouble. I mean, so pipes burst in the winter. And I went 2 weeks with no showings, and when I went to go show the house, the pipes had been burst for like 2 weeks and running through the whole house. And it became a huge deal. I lost about half my commission trying to go back with them. Anyway, it can get ugly.
Oh my gosh. Yeah, absolutely. Those of us down in the valley are like, pipes bursting. Wait, what?
Yes,
Leo
we'll
works
get
up
that
north.
cold here. Anyway.
Yeah. Well, especially last month, you guys got a little bit of that. Yeah. So, well, again, I think that there's something to be said about routinely checking on your listings, but it's not your responsibility. So I think if you're doing that, make sure that your sellers are aware that this is an add-on. This is a benefit that you're providing. It's not something that your agreement requires.
Leah, can I ask a quick question on that? Because I have a listing where nobody's here. They all live. It's their parents' house. They die, yada, yada. So there's been times where something has happened where they've said, can you meet our garage door person over there? Something like that. And it's like, no, I can't. And so I legally can tell them, no, that's not part of my listing agreement. You need to have somebody else, a friend or a relative or a neighbor come over instead.
Yeah, exactly. And realistically, this seems totally innocent, right? Until the garage door opener guy damages the property. Then what? And we were the ones that were there, in essence, instructed to oversee things. I could see where this could become a real slippery slope and problematic. So yeah, my recommendation, again, I know we all want to be helpful, but my recommendation in a case like that would be for liability reasons. I can't actually oversee repairs being made to the property. You'll have to appoint somebody locally to handle that for you.
But
Okay.
how are they going to get in the property without the key? If the key's in the lock?
So I'd probably be okay with their permission, having an option with a contractor's box or getting a key to their contractors. But realistically, even that part, that should be given to the friend or whoever's overseeing that. That's a great question.
Is there something in writing that we can do to cover ourselves if there is? I mean, I have stuff that's supposedly going to come up and I'm like, I don't know if I can really do that. I was going to ask you about that. So this is a good time to do it. So is there something I can do that covers me? Is there a form that I can say, okay, I will take care of this, but I have no liability?
I mean, honestly, no.
Okay.
Even if you have such a form signed, depending on if the courts determine you are doing something outside of your scope or what your agreement allows, the form won't be worth the paper it's written on. That being said, anytime you are instructed to do something, let's use this as an example. So as Renee had asked about handing a key off to somebody else, just have that in writing via paper trail. Don't leave that up to a verbal conversation.
Okay. Yeah. They want to get a bid on remodeling the place, which of course I would be happy to recommend somebody and I can
Right.
go let them in, but I have no say in any of that. But
Yeah,
that would be okay for me to let somebody in to give them a bid on something, but not.
Yeah,
just her.
I'd be okay with letting somebody in. So opening a door. Anytime you start signing off on invoices or work repair bids or overseeing work or anything like that, to go in for the sake of not doing any work, but actually just to provide a bid for something, you're probably safe.
Okay, thank you.
You're welcome. Brandon, I
Leah-
think you had a question.
No, I was just, people jumped in and I think you kind of answered the question, so.
Okay, perfect.
Leah, quick question. Sorry to follow up on hers. If you have them on speakerphone while the vendor is there, to talk through like what the quotes are and stuff, does that help at all, or they physically need to be there?
So they don't physically need to be there for bids. So let's make this distinction. My concern is if you're overseeing repairs. If you are literally letting somebody in that's not doing anything to the premises, they're walking through for the sake of providing a bid, whether you have them on speakerphone or not, doesn't really matter. That's fine. Ultimately, the contractor should just be supplying a bid, probably via email to your client anyway. What I don't want is that they come to start the work that was bidded out, and you're there overseeing that. That would be my distinction for a problem.
Got it. Thank you so much.
And
Yeah.
Leah, what if the neighbor is there, but you also want to be there because you've got the keys and you don't want to leave it open without your supervision? But the
No,
neighbor's still there.
that's the part that I would get in writing from my client, that ultimately they are instructing me to provide keys to the neighbor's name for the purpose of accessing the property with contractors. I wouldn't be there.
Okay, and I can just do that via email. That's a paper trail
Yep, exactly.
since there's no form. Okay,
Yep, exactly.
thank you.
There's no hard and fast rule, no black and white about this, obviously, guys. So we just have to kind of handle it on a case by case basis. So don't take this as universal truths. If you have a specific situation, definitely reach out to your broker so that they can provide you with the best guidance for that situation.
Leah, on that, so I had a situation a couple of months ago where a real estate friend of mine had recommended me to one of her real estate friends who had a listing here in my community. And basically they were out of town, both of them, so no one was allowed to, or no one was around to let the cleaners in to come clean the property pre-close. So they had asked if I could just go open the lockbox and give the key to the cleaners. Is that something that in the future you would recommend I do, especially since I don't even know the listing agent?
No, I wouldn't have done that. I mean, technically, that's a potential armless violation, even with those instructions, because we don't have them directly from the seller and we're not a party to that transaction. I would just say, and again, it's so hard, right? Because we don't want to be a-holes and we're trying to be helpful. And it's not a problem until it's a problem. That's one of my favorite phrases in real estate, because I've seen what some innocuous action was turn into a snowball problem. And that's what we're trying to avoid. So yeah, in a case like that, I'm like, I'm not accessing for the sake of your cleaning person getting in. Like, you need to figure that out, how to get them in there.
Okay, thank you.
Yeah, you're welcome. All right, advertising. So this is one of the poll questions that we had. Owner agrees not to advertise or market the premises in any manner without the prior written permission of broker. Okay, so that's the reason why. Right here it says, and part of this is because they could put us in hot water if they reference anything about compensation, even though it's their stuff. We got to make sure that it's properly disclosed, that things are handled accordingly, that broker logo stuff might be on there, that they have the information correct. Like, we just have to be cautious. So we're not saying that they can't do it. We just have to make sure that they've notified us and that they have permission from us so that we don't bump into a problem.
Leah, I have a question about that. This is
Yeah.
Bonnie. Okay, so I mean, that says what to advertise or market, but what, can they tell their friends and family? I mean, that's advertising, isn't it?
Yeah, it's considered that that's still marketing the premises for all intents and purposes. Now, again, are any of you going to withhold permission, or are any of you going to balk or complain about your seller trying to help you sell their house? Probably not, especially in a case like that. I don't know how much they could screw up by telling their family and friends. This is
Yeah.
really more, hey, be cautious about what you're posting on different pages. We just have to make sure we're staying compliant.
Okay, like if they tell it, at church or something like that.
Yeah.
Yeah, okay.
Hey, if you can get a divine being to help facilitate the sale of your home, by all means, do it.
True.
Leah, would it be okay for us to just recommend then that they only share whatever posts we put out?
Yeah, and honestly, that's kind of a smart strategy for you to instruct them to employ, right? Because then that's getting your name out there in front of their families and family and friends as well. All right. Moving on, multiple listing service. Listing broker is authorized to provide any and all information regarding the premises to any MLS of which listing broker is a participant, and to publish and disseminate such information in print or electronic form to MLS participants and the general public, including dissemination of the information through IDX and virtual websites. Listing broker is authorized to report the sale or rental of the premises and its price, terms, and financing for dissemination through the MLS to MLS participants and the general public. So right there, if they want to complain about, oh my God, why did the sale price show up? Why is it visible on all of these different pages? That's why, because ultimately we have to report it for the sake of closing in the MLS. And then if there's syndication, that will start popping up on other websites as well. All terms of the transaction, including sale price and financing, if applicable, will be provided to the MLS and may be provided to the MLS even if the premises is not listed with the MLS. So for those of you who maybe have an inside deal, where ultimately you were able to put a buyer and seller together in advance, but you want the information available to other MLS subscribers, whether it's for comp purposes or it's for production purposes, this is indicating that it may still go into the MLS. So the sellers would have to tell you no if that's what they don't want. Signs. Listing broker is or is not allowed to place a for sale or for rent sign in conjunction with any customary sign writer on the premises. And in the event of a sale, a sold or pending sign or lease or rented sign at listing broker's discretion on the premises. Seller acknowledges that any public marketing of the premises will require submission to the MLS within 1 business day. I don't think that the sellers necessarily care about that. That's clear cooperation, which you've probably seen a lot about in the media lately. Just so you're all aware, it didn't change anything in Arizona. Nothing is different. This is what our coming soon status, in essence, was already facilitating. But this is really just a reminder for everybody. Hey, the second I start marketing your home for sale, it needs to be in the MLS within 1 business day. Photos and videos. So this is going to be just a list of things, hey, they do or do not. So owner does or does not authorize listing broker to place photos, video, images, virtual tours of the premises on the internet or other media. Owner is cautioned to protect items that are in view. So if there's something concerning, they should remove it before photos and video are done. Owner acknowledges that once images are placed on the internet, neither listing broker nor owner has control over who can view such images and what users may make of the images or how long such images may remain available on the internet. So we have had a few in the past that were very upset their home had sold. In some cases, it was the buyer that said, well, you can kind of figure out my floor plan. So if somebody is, trying to determine how to break in, this is far-fetched, but it is what it is. This is the complaint that we got, that those photos would allow them to do so, and they wanted them removed. And we're trying to explain that if we could control Zillow, madam, I would not be doing this job. So ultimately, that is outside of our control. Once it's on the internet, it's out there for however long. So they just need to be aware of that. Is or is not authorized to install a lockbox or key safe. A lockbox or key safe is designed to hold a key to the premises to permit access to the premises by listing broker, cooperating brokers, MLS participants, their authorized licensees, representatives, blah, 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 blah. All these people. If premises is rented, owner must comply with providing proper notice to tenants pursuant to Arizona law. So even if the tenants say they are agreeable to showings within 24 hours, that agreement cannot supersede Arizona law, which says 48 hours. So please make sure you're not inadvertently violating that by believing it's okay simply because the tenant said so. They are protected by something higher than anything they can put in writing. So ultimately, for your tenant occupied listings, make sure that you are giving that 48 hours notice before any showings can occur. Listing broker is or is not authorized to disclose the existence of offers, which includes the sales price in terms of sale or rent price in terms of lease on the premises. So generally speaking, I get snarky. So especially in the case of multiple offers, if I were to call as the buyer's agent and I ask the listing agent, hey, do you have other offers on the property? They say, yes, we do. Say, excellent. Can you let me know what those terms are? The number one response we get back is, no, I cannot. Or no, of course not. No, I'm not allowed to share that. And then I'm going to follow up with, oh, is that how you have it marked on line 187 of your listing agreement? And they get so stumped by this questioning that ultimately there was an option for sellers there. And I have a sneaking suspicion that the majority just automatically marked is, which means that, yeah, you are authorized to disclose the existence of other offers, actually. So let me know what we're up against. One caveat to this: if one of those offers on the table is a limited representation offer, okay, it's from the same an agent within the same brokerage, the same designated broker, you cannot disclose the existence of other offers, because in essence that is a detriment to that prospective buyer by letting other prospective buyers know what they're up against. So just make sure you're aware of that. That's kind of a little known caveat to this, but otherwise, yes, it's allowed by marking that box. If not, then they would say nope. In that case, then the answer is just give us your highest and best. Subsequent purchase or lease offers, listing broker acknowledges that owner has the right to accept subsequent offers until the close of escrow in the case of a sale, or until occupancy by a tenant in the case of a rental. Owner understands that any subsequent offers accepted by owner must be backup offers, namely contingent on the cancellation or other nullification of any contracts arising from the acceptance of earlier offers. This could happen where ultimately they're in it to win it, right? Once that seller signs a contract, the expectation, the contractual obligation is that they are proceeding to close of escrow in good faith. So if they are to get a higher offer after they've already signed one, there's no 3-day right of rescission. There's no period under which there's a seller contingency unless that was something negotiated in the offer that they accepted. So they are going to be working with that original buyer unless that original buyer cancels, at which point they can proceed with a backup. So based on that, the sellers have a couple of choice. Accept backup offers, okay, that's usually the additional clause addendum. Withhold verbal offers, I'd say that's probably a good one. And withhold all offers. So you could have both accept backups and withhold verbal checked. You could have withhold all offers checked singularly. There might be more than one, is kind of the general gist of this. But you shouldn't have all three because that would be contradictory. Once owner accepts purchase contract or lease agreement for the premises. So some of them may tell you, hey, withhold all offers because if one comes in higher, I don't want to know about it. That ultimately I will probably feel badly and I'll be upset. So just withhold so I don't even know it exists. Listing broker will change or maintain the correct MLS listing status in accordance with the MLS rules and regulations and any associated policies. So we already referenced that above, but we're reiterating that. So even if you tell me, hey, put it in active or keep it in active status, the answer is no. We're going pending, UCB, or CCBS, depending on the circumstances. Listing broker reserves the right to cancel this agreement unilaterally for cause, which shall include but is not limited to listing broker's good faith belief that any service requested of listing broker or any action undertaken by anyone other than listing broker is or could be determined to be in violation of applicable law. The big one there is fair housing. So ultimately, if your seller says something that would indicate that they are either violating fair housing laws or they are asking you to, that's grounds for immediate cancellation of that listing agreement. Some others here that we've had some sellers who are verbally abusive to the agent. In some cases, I've taken over. The seller was not verbally abusive to me, but in most cases, we're just going to go ahead and dump it. Especially if it's just a listing, it's not under contract. If it's under contract, it's a little more sticky. But if it's just a listing, yeah, nobody needs to deal with that. We're going to get rid of them.
In that situation as well, would you still recommend canceling with selling that?
So Lacey, you're kind of muffled. What was the question?
Oh, sorry. I said in that situation, would you recommend canceling it or expiring it based on what you said earlier?
I don't want to work with these freaking people ever again, so you can cancel it.
Okay.
Yeah.
But I want my money.
Seriously, if somebody's screaming and yelling at me, that's not somebody I have any desire to work with. So we're done.
Fair enough. Thank you.
Yeah, you're
Leah?
welcome. Yeah.
Can you reiterate lines 187, 188 regards to the limited representation?
187 to 188. Okay, hold on a minute. Yes. So if you have multiple offers and one of those offers is from, in your case, another Realty One Group agent, and an agent calls and says, hey, can you disclose the terms of other offers? The answer is no. That anytime there is a multiple offer situation where one of the offers on the table is either you personally have the buyer or another Realty One Group agent or someone within your brokerage has the buyer, it's a detriment to that buyer to disclose the terms of their offer to other buyers. So you just can't disclose it. The answer is always no in the case of dual agency if there's multiple offers on the table.
Okay, so it was referencing to the buyers. Okay, I get it. Even if you get that permission though?
If you get the buyer's permission?
Well, buyers or sellers permit. Like if I'm the seller's agent, if I get the seller's agent's
No,
permission.
because in that case, you're not just the seller's agent. So remember, in a dual agency situation, even if it's not you personally, you equally represent under the broker both the buyer and seller. So if you had the buyer's permission to disclose the terms of their offer to other prospective buyers, I'd say you're okay, but I don't know why they'd give that to you.
Thanks.
Sure. Brandon.
So this says that you're authorized to disclose the existence. That doesn't mean you have to, correct?
Yeah, correct. And obviously that word was chosen for a very specific reason, and it's to cover this case.
Okay, so you could say, is authorized to disclose, but then if they ask you, okay, well, what's the highest price you've gotten? You could say, well, I'm not at liberty to discuss that. Or do you need to have that written into the additional terms that you can't talk about price?
You might want to go ahead and have that in the additional terms, or honestly, this may be more on a case by case basis, depending on the circumstances. Like, I think this is a conversation with my seller if multiple offers start to come into the potential mix here, where I'd say, hey, here's what we originally marked on this box. I've already received 3 offers, and I'm getting asked the question if I will disclose what's on the table. And let's assume none of them are from my same brokerage at this point. How do you want me to handle this? Do you want me to go ahead and tell them what they are and let them play against one another? Or do you want me to vaguely tell them, hey, we have 3 offers. Please submit your highest and best by such and such date. And then we'll just take their guidance at that point in time. All right, poll 4. True or false? A seller should initiate and complete the lead-based paint disclosure at time of listing. True or false? A seller should initiate and complete the AAR solar addendum at time of listing. And true or false? In the case of a dispute, a seller may immediately take legal action against the listing broker and file with the court.
Leah, can I ask a question?
Of course.
I have limited representation and the seller is asking what the appraisal came in at.
Mhm.
It's quite a bit over. Do I have to disclose or do I just go ahead and say I do not know?
So you can't say you do not know because that's a lie, right? But ultimately, this would be up to the buyer if they are willing to allow you to disclose that to the seller.
Okay, so I have to check with the buyer.
Yep, exactly. So you personally cannot share that information. This would have to come, and I get written permission from the buyer to share that. I have a sneaking suspicion, again, I have lots of those, that no good will come from this. How far along in the contract process are you right now? Are you already past inspections and all points?
Yeah,
of
we're past inspections. We are closing April 10th. It's been a friendly transaction all the way up to now, but there's 58, like there's a lot of money on the table and I'm just.
Yeah. Yeah, I think this is one of those where, you know what, I'll gladly tell you after closing. That would be my response if I was the buyer.
Okay, so check with the buyer and have the.
Check with the buyer, but ultimately, so I'm not advising them on terms, right? This is a, hey, here's the risk of doing this. They may think, oh, we can get more for our house, and they could potentially make things difficult. I'm not saying they're going to, just in general, that's a potential risk. That's something that you can share with the buyer, and then they can determine, okay, then in that case, don't share the appraisal value. They say, we're not worried about it. You can go ahead and share it, but put it in their court so that they know why they maybe shouldn't, but ultimately they can make that decision.
Okay, so disclose their risk and let them make the decision.
Yep, exactly. Which
I
is,
appreciate it.
yeah, no problem. So just kind of generally, well, a couple of you are still answering this. This is how I've always recommended you handle, I mean, really how you handle business, but especially in a dual agency or limited representation situation. I'm all about, hey, I'm going to give you facts, figures, and probable outcomes, and you can tell me what you're willing to do in those situations. I just can't tell you what I think you should do. That's
Okay.
really what is taken away from it.
Thank you.
Yeah, you bet. All right, let's go ahead and let's end this guy and share the results. So true or false, a seller should initiate and complete the lead-based paint disclosure at time of listing. That is true. Get that now right up front and put it into your MLS Docs tab so that the buyer can include it with their offer. But always, 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 the buyers are acknowledging receipt of that document on the bottom of that document. So if they originate it, how are they acknowledging receipt of something they haven't actually received? It's backwards. So best course of action, if lead-based paint will apply, yes, bring that and have the seller get that all filled out and upload it to the MLS tab. True or false, a seller should initiate and complete the AAR solar addendum at time of listing. Also true. And same thing, same process that as you're about to see, the listing agreement says, hey, seller, you're going to do this. But there's a few things on there that a buyer may not otherwise know. So it's good to just have that filled out so that you can go ahead and upload it.
I took this whole survey wrong. I was thinking the seller should initiate, but it's really us that needs to tell them to do it because otherwise they don't really know, correct?
Yeah. So by initiate, I mean that in essence, the document should start on the seller side.
Okay, I totally miss, yeah, okay.
That's okay. I don't know who put true and false, so you're just tattling on yourself. True or false, in the case of a dispute, a seller may immediately take legal action against the listing broker and file with the court. That is false. So ultimately, we have a thing called ADR, which is alternative dispute resolution that I'll show you, but there's a process involved in what they need to do. So some owner obligations. Owner shall provide access to the premises at reasonable times and upon reasonable notice to allow for showing the premises to prospective buyers and cooperating brokers. And that line is actually reiterated again in the purchase contract when it comes to inspections and walkthroughs and those kinds of things. Security insurance showings, audio and video. Broker is not responsible for loss of or damage to personal or real property or person, no matter the circumstances. So this is because, hey, sorry, yep, the lockbox let them in, but that doesn't mean that we're responsible for everything. And that ultimately the seller is to make sure that they have the appropriate level of insurance to protect against any of these risks throughout the listing process. Persons visiting the premises may not be aware that they could be recorded by audio or visual devices installed by owner, such as nanny cams and hidden security cameras. Owner is advised to post notice disclosing the existence of security devices on the premises, if any. That could potentially be in a line, that could be in semi-private remarks, it could be a note on the door, bearing in mind that state law does not require this, so they don't have to do it. Really, it's just a matter of we would advise them in the effort of making sure that there's no issue with what they are using as leverage as far as treating parties fairly, and that there's no potential fair housing problems, that they go ahead and they make sure that everybody's aware that cameras do exist. Owner has disclosed to listing broker all material latent defects and information concerning the premises known to owner, including all information regarding to sewers, any tax liens, things that could potentially blow up closing, right? Past or present termites, specifically, past or present repairs that were made for that reason. And during the term of this agreement, owner agrees to continue disclosing to listing broker all additional information of the type required by the preceding sentence promptly after owner becomes aware of any such information by updating the seller's property disclosure statement or the lease version of that. So really that's, hey, if something does occur to the property while it's listed, A, notify me, and then B, we're going to update the SPUDs, which you can do a couple of different ways. But that notice, the AAR notice disclosure form, is probably the best way to update the SPUDs. And you could have multiples of that form if there are multiple updates necessary. But that's one way. The other way is you can update the SPUDs directly and then just have them put their initials and the date next to that update on the SPUDs form. Obviously, that's only during the listing period. After contract, you'd have to use the notice disclosure document for that purpose. Disclosures. Owner shall provide listing broker with accurate information about the premises. Owner acknowledges that Arizona law requires owner to disclose material important facts about the premises even if owner is not asked by the buyers or a real estate agent. Okay, and we have the SPUDs to help facilitate that, but there's actually a whole bunch of documents that can help. So if it applies, any of these documents are considered part of seller disclosures that would have to be supplied as part of the contract process. Your affidavit of disclosure, your lead-based paint, your water well addendum, and the water well addendum disclosure, property disclosure statement. So there's 2 of those when you're looking, FYI. And the little seller property disclosure statement on the well SPUDs is very small when it's on the form itself. So make sure you will have both the addendum itself plus this well addendum SPUDs. FERPTA information for their tax certificate, really, we just need to make sure that they will do whatever is necessary with the title company to successfully facilitate that and make sure the taxes are paid accordingly. Page 1 of the HOA addendum should be signed and filled out by them, not by you as the agent. Their insurance claims history, formerly known as the clue. Please don't call it the clue. That's not what it is. It is a claims history or a letter of experience. I encourage my sellers to request that right away, again, so that I have it as soon as we have an offer. We're not trying to track it down after the fact. Any residential lease agreement that might be in place, obviously they need to be aware of that if they're going to have to uphold it. The residential lease SPUDs, they're going to have a copy of all of that to make sure that it's covered and they have documents relating to that lease if they are taking it over. The SPUDs themselves and the solar addendum. So then obviously all of these individual documents have their own disclosures within those as well, but these are just a handful of the documents from a disclosure purpose that we would be looking for if they do apply. If the tenant is the one approving showings, does it still require 48 hours? Yes, it does. Yeah, so the tenant's approval cannot supersede state law. So no matter what, it needs to be 48 hours. So when you're setting those up inside of aligned or showing time, whatever you're using, make sure that the minimum is a 48 hours before somebody could even request an appointment. And that'll help alleviate that problem. If listing broker recommends a builder, contractor, escrow company, title company, pest control service, appraiser, lender, blah, 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 any of these, such recommendations shall be independently investigated and evaluated by owner, who hereby acknowledges that any decision to enter into any contractual arrangement with any such person or entity recommended by listing broker will be based solely upon such independent investigation and evaluation. Owner understands that said contractual arrangement may result in compensation or fee to listing broker. So there are certain things that you could actually be given some sort of compensation for, like alarms. I would probably have that in writing, but ultimately, if they're not a settlement statement partner, people where RESPA would come into play, you could make some money off of these referrals, and that's just letting them know about that. Owner
Wait.
agrees. Oh, yep.
I'm sorry, quick question.
Yeah.
Wait, on the 24-hour notice, so I usually give 2-hour notice. What do you mean 24-hour notice? I'm a little confused on that with the line or showing time.
No, 48 hours notice. So if
Right.
you have a tenant, even if the tenant is
Oh,
the one
tenant.
approving the showings, your base space for the earliest opportunity for somebody to make an appointment would need to be 48 hours out. So you'll have to set that 48 hours parameter inside of aligned or showing time.
Gotcha.
Sorry if I misstate. Did I say 24 hours before? Did I misstate that? Sorry if I did. It's 48 hours.
Thank you.
Yeah, no problem. Owner agrees it will not allow mechanics liens to be recorded against the premises during the term of this agreement or at any time prior to close of escrow. That's reiterated in the contract as well. Don't do something that's going to cause a problem for payment purposes because it will blow up closing. Owner hereby expressly releases, holds harmless, and indemnifies listing broker, all boards or association of realtors, MLS, and all other brokers from any and all liability and responsibility regarding damage or loss arising from any misrepresentation or breach of warranty by owner in this agreement, any incorrect information supplied by owner, and any facts concerning the premises not disclosed or withheld by owner, including without limitation, any facts known to owner relating to adverse information or latent defects. So if we all get pulled in to some sort of lawsuit for failure to disclose something, this is what we're going to bring to the table and say, we only had an obligation to disclose things about which we were aware, and the owner, the seller, intentionally, potentially, withheld information from us. So we were not aware, so we could not disclose. And that's indicating, hey, you're going to be on your own, seller, if you do something you shouldn't do, fail to disclose something you should disclose, don't tell anybody, and you're ultimately sued for it. So I discussed ADR. If it gets this far, speak with your broker, but ultimately this is just telling both parties, hey, you can't jump straight to a lawsuit. Okay, we have this process called ADR. It's going to involve mediation and arbitration, which is ultimately binding. There are some opt-out opportunities, but ultimately we got to follow the chain of command before it gets to any sort of actual litigation. And then if it does go so far as litigation, then attorney's fees and costs, whoever wins will ultimately be entitled to collect reasonable attorney's fees as part of their damages as well. Like I said, agents, while it's good to kind of explain the process to sellers very briefly, just like that, don't go too deep into the weeds on this, because if it goes here, you're probably mostly out of it, and now it's going to legal counsel and brokers to handle. All right, our last poll of the morning. Oh, there's only one. I made it so easy. What clause must go into the additional terms of every ER? An early termination clause, a buyer broker compensation clause, a strategic price reduction clause, or no additional clauses are required? Ten seconds. Oh, Brandon, do you want to ask before I go into the answer?
Sure, it's not on the topic of this, but it goes back to liens. Is there what would be the best resource for me representing a buyer looking at homes to go and check to see if there's any mechanics liens or tax liens or anything like that recorded against the property that they may want to make an offer on?
Yeah, your title company is going to be your best bet. I mean, realistically, they have resources beyond what we have access to verify at least anything that's been recorded that they would have access to. Other than that, it really is going to rely on seller disclosure.
Okay, so there's no website like the county recorder or anything like that where we could go look and see?
If it's on there, it ultimately would be available through the title company, and the title company might have even more information, because sometimes things aren't removed appropriately or the timeline of things isn't adjusted accordingly. And your title folks are able to handle a lot of that more efficiently. So I would still, like, yes, you could go to the recorder's office, but I don't know that you can pull, and this is my own ignorance, I don't know if you could pull up every lien based solely on like a parcel number or an address. I feel like you might have to have more information to get what those recorded liens might be.
Okay.
All right, so the answer is no additional clauses are required. I'm going to share some clauses with you that might fit your situation and you may want to utilize, but at the end of the day, there is nothing extra that is required unless you have something that your broker is specifying must be included. Talk to them, but as far as I'm concerned, there's not. If you were to have any additional terms or clauses, this is the section that it would go in. Assignment, neither listing broker nor owner may assign any rights or obligations pursuant to this agreement without the prior consent of the other, and any attempted assignment without consent shall be void and of no effect. So this has nothing to do with the purchase contract and buyers like assigning their rights. This is exclusively between us. An assignment would be rare anyway, but ultimately we're just saying, hey, you, like everything else in here, it's a bilateral agreement. You have to have the buy-in for that. And I didn't think this would be as important as it has become in some cases. This agreement shall be governed by Arizona law, and jurisdiction is exclusively conferred on the state of Arizona. So no matter where the client lives, if there is a problem, this is where that issue is going to be handled. We're not going to California to deal with a problem that they have with our contract, nor are we going to abide by California laws that don't apply here to Arizona. Unless otherwise provided, delivery of all notices and documentation required or permitted shall be in writing, addressed to owner or listing broker as indicated in sections 11 and 12, which are coming up, and deemed delivered and received when, same thing that the purchase contract says for all notices, right? Hand delivered, sent via fax, sent via email, or sent by a recognized courier service. In this case, or sent by U.S. mail. in which case the notice shall be deemed received when actually received, or 5 days after the notice is mailed, whichever occurs first. That last one is really more designed for the rental side of things as far as notices go. But the other few are probably your better options anyway as far as tracking goes. All references to days shall be deemed to be calendar days, same as the contract, copies and counterparts. It could be done in multiple counterparts. That's not a problem. Just make sure we have copies and that we are providing copies to anyone who signs. So let's say that we have 2 different sellers. They both signed separate versions or separate copies of this same agreement. For whatever reason, it might just be a legibility issue and they're in different locations. Merge it all together and then make sure that you send out a fully executed copy, which includes both of those with your signatures on them now, to both parties as soon as possible. I think the phrase is actually as soon as probable, but we're going to say ASAP. Get that out so that they have copies of all of their documents. This agreement and any addenda and attachments shall constitute the entire agreement between owner and listing broker and shall supersede any other written or oral agreements, which we know whatever is in writing is what is going to be the standard that we're holding. Invalidity or unenforceability of one or more provisions of this agreement shall not affect any other provisions of this agreement. The failure to initial any page of this agreement shall not affect the validity or terms of this agreement. You know, somebody complained about that, right? Well, I didn't initial that page, so nothing on that page applies. Incorrect. It all applies. The undersigned agree to the terms and conditions set forth herein and acknowledge receipt of a copy of this agreement. So that's why it's important. So realistically, you should be getting a copy of them like now, meaning you brought multiples potentially to the listing appointment if they're actually signing at the listing appointment. But that seems kind of awkward and weird. So we're going to go with, yes, they're acknowledging a receipt, a copy of this agreement, even though they might be receiving it via email once I get back to my computer to send it to them later this afternoon.
Leo,
And then it's
there's
just
a
gonna be,
question on that. I'm sorry.
yeah, that's okay.
I forget who brought it up earlier that has the lawyer as their client.
Mhm.
But in that regard, if she were to X out or cross out that spot, does the overall signature of this contract then mean that their crossing out is void because it doesn't
They won't
matter?
be crossing. Let me make this easy. They won't be crossing that out.
Okay.
As a listing agent, as a listing broker, I wouldn't allow it. So that's not a clause that's negotiable. That's going to stay in there.
Okay. Well, no, sorry, not that one. She was asking about crossing out one of the other clauses earlier on. Whether you cross it out or not, you're still bound by this agreement per that last statement.
So not necessarily. So depending on the clause, if that's crossed out and in essence it's specified that that specific clause is null and void and that's initialed by both parties, then that would be upheld, that that's fine. What this is indicating is the lack of initials, not necessarily crossing something out, but the lack of initials to a page is not going to invalidate the terms on that page.
I see. Okay, thank you.
Yeah. So owner and listing broker, fill in the blanks, right? The majority of you, I think, on this call are members of WeServe. You might be a member of PAR. That's what would go into 322. You could be SAR or whatever the board is, but that should be your local association. Periodically, I see AAR. That's okay. But yeah, generally speaking, it's going to be your local. You should include your owner's contact information on here for one primary purpose, or at least make sure that it's accurate in your file, whatever system you're using. That is in the unfortunate case that something happens to you, you're hospitalized, God forbid something worse happens to you, and we need to communicate with your seller who is listed or under contract and let them know what's going on and take over the deal to make sure that everything goes smoothly. We need their contact information so that we're able to do that. So I would encourage you to at least have a telephone number or an email address on there so we have some means of doing that should the need arise. And I'm just going to leave you with a couple of these. Again, I'm not saying use these. If you are not with Realty One Group or not with me, make sure that your broker is okay with some of these if you want to implement them. But these are just a couple of helpful ones that I've utilized in the past. So strategic price reductions. In the event that property does not have an accepted offer by such and such date, the list price shall be reduced by however many dollars, and additional number, let's say $1,000 reductions shall occur every 14 days thereafter until an offer is received and accepted. Like, I don't play these games with sellers. At the end of the day, we're coming up with hey, if you are not under contract by this date, and it would probably be about 14 days out from now, we are going to reduce the price by $5,000. And then we're going to continue to reduce the price by $5,000 every 14 days until we are under contract. I want their buy-in on this right away. And by doing this, I don't have to do a whole bunch of sold change forms because I already have their written permission and instructions to facilitate this. The clause for ER. So this is, and you'll see, this is not my recommended method. I would stick to keeping it 100% negotiable in the purchase contract. But if you have a seller, and we've had a few who are from other states and maybe are retired agents who understand the benefit of and wish to actively promote a designated amount of buyer broker compensation, you would be able to utilize this clause for that purpose. So this is, hey, we don't want to make it negotiable. Again, I recommend keeping it negotiable. Let them ask for how much they want, and then you can counter accordingly. But if they want to designate an amount, they would be able to do this right here. So seller wishes to offer buyer broker compensation in the amount of whatever percent or dollar amount. This is separate from and in addition to the listing broker compensation set forth on line 46 of this agreement. Seller further authorizes and instructs listing broker to communicate this offer of compensation to prospective buyer brokers and requests that they submit the seller compensation addendum accordingly. So the end game, the end document is the same. It's still going to be the SCA in either circumstance, but this is giving you a specific amount that you can share in advance, just not on the MLS. An early termination clause, I think more of you should implement something like this. Should seller wish to terminate this agreement prior to the expiration date and broker agrees, seller shall pay listing broker an early termination fee of X dollars. If this is a situation where you didn't charge an upfront retainer fee, fine. But now they're displeased with your services, you don't want to deal with them, they're PETAs, and all around it's just a bad vibe. You still should be compensated for, cost of your marketing, any videography that you've done, photography, etc. So this is definitely something that you could put into that. Delayed listing input for MLS. So this is not coming soon. So this is a circumstance where they're not looking to market the property in any way, but your armless rules and regs say that it needs to be uploaded within 2 to 4 days of having your ER signed, unless you have separate written instructions about a delayed listing. So property shall not be listed in the MLS or marketed in any way. Okay, that's critical because remember, due to clear cooperation, you can't market it on other sites or put a sign in the yard or anything until further written instructions are received from the seller. I tend to see this a lot in active adult communities, especially with estate situations. They just need a delay. They're willing to sign your agreement with you now. Fabulous, do it. But ultimately, they don't want it on the MLS. They don't want photos done. They don't want any of that for 30 days out. And that's fine, but you just need a little clause to help protect you in that case. Any other questions?
Hi, Leah.
Hello.
Hi, my question is in the number 322. Do you say is agent is a member of the NAR or the local association board?
Yeah, so you're talking about on the page where you're filling in line 322?
Yes.
Yes. Yeah, so for you, it would be we serve.
Oh, we serve?
Yep.
Oh, okay, thank you.
You're welcome.
I have a question about the MLS input sheet.
Yes.
So who ultimately should be filling that out?
That's going to be ultimately the agent, like that's not a disclosure document where the seller would be responsible for that. However, I doubt the seller knows most of what goes on to page 1. That will come from general public information, tax records, etc. So my general standard of practice for that is I will complete page 1. And then during the listing appointment, I will sit down with the seller and we will go through each of those other categories and have them tell me the appropriate boxes to mark.
Thank you.
Mm-hmm.
I have a question about personal property. It always ends up being such big drama when they want some things, but they want some stuff out of the house, and then making sure there's a check for them. That's because it's outside of escrow. How do you handle that kind of stuff?
Well, my best recommendation is don't. So we have a
Right.
bill of sale that can be used even if it's for $1. I would still recommend don't negotiate the items within the contract itself, unless it's just a onesie twosie type thing, like the pool table. Yeah, that can be in the contract. But if we're really discussing furniture and artwork and other stuff, have it on a separate bill of sale for $1. And our separate bill of sale indicates that that's all being handled by the buyer and seller outside of escrow. It has no impact on escrow, has nothing to do with us. Money's not changing our hands. They're going to deal with all of that however they want to deal with it.
Excellent. Thanks.
You're welcome. Anybody else?
Leah, I still have a question on the landlord tenant act where it's required that the tenant have 48 hours notice before showing. But you know, I mean, most prospective buyers are not going to wait that long. But I mean, if the tenant says, you know, I'm fine, and you know, I mean, is it a big deal for them to have it shown before the 48 hours is up?
You want the Leah response, Bonnie, or do you want the broker response? So the broker response is don't violate Alta and the state law, right? If you have a tenant who's willing to allow you all to violate this, no one's going to be any wiser. Here is the potential issue. So like I said at the beginning, it's not a problem until it's a problem. So should the landlord or should one of the showings result in something that irritates the tenant, now they have some pretty significant recourse.
Well, what if they put it in writing?
Won't matter, won't supersede it.
Oh, okay.
I know there was a big push for a while that you couldn't even install a lockbox on the property when it's tenant occupied. That's since become like, hey, no, you just have to have written permission from the tenant to do so. But yeah, they couldn't even do that because that could allow unauthorized access to the premises.
Oh, geez. Okay.
Yeah, it can get ugly.
Okay. Thanks.
Yeah, no problem.
Great class.
Thank you. Well, I'm gonna let you. Oh,
how
go
come
ahead.
how come you don't do it 3 hours and then so we can get CE hours?
Oh God, because then I have to go and I've got to get my instructor's license. I don't know. I might love all of you enough that I'll consider doing that in the future. I've just been too lazy so far.
Okay. And great class. Yeah.
All right, everybody, it's 11 o'clock on the dot. Thank you for joining me this morning. Everybody who registered is going to get a copy of these slides along with a recording in case you want to go back and listen to my made for radio voice. That's like what your appearance should be, but ultimately I know how I sound. If you do have questions along the way, reach out and let me know. I'm happy to answer them, but I'm going to let you all go. Enjoy the rest of your day.
Bye. Thank you, Leah.
My pleasure.
Thanks, Leah.